Hi dear students, we are in the week where we don't meet, and then I provide you with an audio to go with the PowerPoint presentation. And this week we're talking about the attorney-client relationship. And in general, it's a really highly ethical relationship that we have to have with the client. So it's much different than dealing with people in our average everyday lives, or even, for instance, a retail job. So we're going to get into that a little bit more. I'll let you read your goals and objectives on your own. So let's go on to variables affecting client relationships. Okay. We are constantly thinking about money and law because our clients are worried about how much things are going to cost. But sometimes in order to do the best job, we need to spend extra money. So maybe we have an expert witness for a case. Maybe we have a trial software that helps us do a better job. Most attorneys and paralegals now are starting to specialize. Why? Because the law just keeps growing and getting more and more complex. And so it's kind of almost necessary to specialize, and there's not a lot of general practitioners anymore, if you will. Alright, so I'm talking with you about the things I really want you to focus on your slides. I'm not going to reread them to you, and I'm just reminding you of that. So we've moved on to the State Bar of California, basically. And this is the entity that regulates attorneys and, by extension, paralegals. And a lot of attorneys think that they have to follow the American Bar Association rules, ABA rules regarding ethics. In California, we typically have a much higher standard of professional responsibility or ethics code, and a lot of the rules have just changed, and most attorneys in the state aren't really up to date on them. Unfortunately, that means that you don't get, just because you don't know the law doesn't mean you're excused. These rules also apply to paralegals as well, so it's really important to read them and follow them. In the Intro to Legal Assistant class, we really cover the ethics in depth. The other thing that's interesting about the state of California is we are one of the two states in the nation with the highest number of attorneys. So usually that's almost always California, and then it's also New York. And so for a while they were trying to limit the number of attorneys that could get barred in the state of California, but then they realized they needed more attorneys to help with all the clients that need free legal help. So then they've started readjusting the bar exam to make it easier. Now, the role of a lawyer, let's talk about these three roles. We really are called counselors, and we do counsel our clients about what is best to do in their particular legal situation. I do a lot of listening. I do a lot of negotiation and helping to resolve conflict situations. I'm also an advocate, though, so sometimes I have to be a little bit adversarial at times to get the best deal for my client. And what does it mean to be an agent? Well, I'm almost like an extension of my client, and sometimes I can sign documents on their behalf. I'm supposed to really think about the amount of time I'm charging them. Is it absolutely necessary? I'm supposed to do as good a job as possible for them. All right, so this goes into a little bit more detail about the duties of an advisor. Unfortunately, in law, I have to often tell people things that they don't want to hear. And this is something that I think in general we try to avoid in society. We try to avoid saying things to people that are considered perhaps too honest. But my mandate in law, part of the rules of professional responsibility, says I have to tell them, unpleasant news at times. Also, I can't help my client commit a crime. So a client might tell me that they're thinking about committing a crime, and I must do everything I possibly can to dissuade them from doing that crime. So sometimes people come to me and say, well, I want to get out of paying my taxes, for example. And I'll have to discuss that with them and let them know that I cannot help them get out of paying taxes that they have to pay, but if we can find perhaps a good tax deduction that's legal, we could do it that way, legally and ethically. All right, so more about the duties of being an advocate. Sometimes clients come to me and they want to start a frivolous lawsuit. So I used to love going to the courthouse because it was the only time in my day I would get out of the law office and then walk and go file things. And now, of course, we can electronically file almost everything. So when I would go walk to the courthouse and I'd file something on the second floor, there'd be a lot of people there, and they noticed I was an attorney, some of them, and they'd ask me for help. And occasionally, it would be, well, for example, one time I had a homeless person let me know that he wanted me to file a lawsuit for him because another homeless person stole his teddy bear. So this is an actual thing that happened to me, and it's very sad, of course, and it's something that the person was very attached to, but there's not a real legal recourse for that situation. So I can't just sue because somebody wants me to sue. There has to be a valid legal reason that they can sue. All right, going more into the duties of an agent, we have to do the best for our own client while, and this one's so hard to talk about because I feel like so many attorneys, unfortunately, just try to do the very best for their client at the expense of all others. But we're supposed to be honest and fair with the other side as well. And particularly in criminal law, like with the prosecution, like they have to hand over a lot of their, almost all their discovery to the other side. So it's fair, open, and honest when you have a criminal trial. All right. The role of the client. Well, the role of the client is we need them to tell us just about everything about their case. And we need them to also be as truthful as possible. But one thing we forget to do, I think, enough in law is to really sit and listen to what the client has to say. Really hear them. Treat them like a human being. Be upfront about how much things are going to cost. Not avoid them. Take their phone calls whenever possible. Explain things. Let them know what's going on. And we get so busy in law, and going back to that, one of the first slides about the economics of law, we're always worried about charging the client for too much. But we need to kind of calm them down about their lawsuit. They're going to do a lot better in their lawsuit if they understand their process and we explain what's going on to them. So that's a really vital role that we have. So we already kind of talked about this with the role of the client slide. You know, most people have a point of view, and that's not always the way it would be if we actually videotaped an event. So we have to kind of try to shift through that point of view. It's not that the person's lying to us, it's just that they see it through their life and their experiences. And a lot of times, clients don't want to tell us embarrassing past situations. Like sometimes a client won't want to tell me about a drunk driving conviction. Well, unfortunately, most of the time, I really need to know about that because that can be brought up in a lot of different lawsuits. And I can't do my best job for the client unless they let me know everything that's happened legally in their life before, pretty much. I also wish that clients would remember that I can't do anything unethical or illegal for them. And sometimes it's just a simple matter of educating the client that that is something illegal or unethical. Sometimes clients will ask me, oh, you won my case for me. Is it okay if I go and post it on Facebook? And I'll let them know, yeah, it's fine for you to go post it up on Facebook, but I'm really not allowed to go and publicize your case. And in fact, if I talk about cases on social media at all, it would be so general that nobody could figure out who I was talking about. And we're seeing a lot of violations of this lately, and there's been a lot of crackdowns, but not nearly as many people are caught as are doing it. And it's something that we really have to think about as a paralegal and a lawyer working on a case, that we need to keep this all confidential and not be talking about it with our spouses, our friends, on social media. I really also appreciate it when clients can pay my bills regularly and on time, and that they understand that sometimes I ask them to replenish their account. So these are just things that we need to understand about each other as attorneys, paralegals, and clients. I think this slide is one of the more interesting ones because across the nation, most attorneys receive 50% of their future clients from clients they already have. I've been really, really fortunate in that I got to work for a lot of big law firms and big corporations, and then I went out on my own. So, you know, I worked with Pizza Hut and Del Taco and Domino's. Those were my fast foods. And I worked with Marriott. That was a hotel company I worked with. And then I worked with Target, and I worked with school districts, and on and on and on. And so because I'd had all this experience, it was pretty darn easy to go ahead and get clients through my past clients. And I would say my client recommendations is more than 50% of my business to this day. I do 0% marketing, and that's really fortunate for me because marketing is expensive. Friends and relatives also, I ask them actually not to refer me because there's this whole rule of ethics about runners and cappers, and so, you know, I've had to say, hey Mom, okay, you can mention I'm an attorney, but don't go around giving people my business card. I mean, if they ask for it, that's one thing, but Mom, I know you're proud, but you can't go around handing out people my business card because there's rules about soliciting business and law. But friends and relatives also ask me for help quite a bit, so I will get some cases from them as well. But most of my business does come from prior client referrals, so it's really important to keep the clients that we have happy so that they do refer us for future cases. Now, advertising activities. So I just kind of touched on this. It's very limited in how I can advertise and what I can say, like in a newspaper. Not too many attorneys advertise too much in newspapers or magazines anymore. But even like the letters I send out, it's got to be very clear who's the attorney, who's responsible, who's a paralegal. A directory I can be a part of, and all attorneys are basically stuck in there whether they like it or not, is Martindale-Hubbell. And so you can actually look at the Martindale-Hubbell website and find out a little bit about attorneys. You will hear a lot of radio and TV ads that, if they are broadcast in the US, it's usually very in line with what's going on. But there have been instances where US attorneys decided to broadcast from Mexico to get clients in the United States, and there have been issues about whether or not there was an appropriate supervising attorney mentioned on that radio and television ad, if results were not guaranteed. Attorneys of all different types trying to go around these rules sometimes, and so we have to be aware of that. Even websites, we need to make sure it's clear who's the attorney, who's the paralegal, who's responsible for the legal work, and we've already talked about the social media aspects. So this is an example of a legal ad that is acceptable, and so you can go back to your original PowerPoint and get the video to play, and I recommend doing that. Alright, this goes into other marketing activities that can happen. A big thing that attorneys do is these other promotional activities. So sponsoring seminars, continuing legal education events that all attorneys and paralegals have to do. Paralegals have to do 8 CLEs, continuing legal education units, every 2 years, and 4 of those must be in ethics. You must start doing that once you become a paralegal. Attorneys must perform 25 hours of continuing legal education units every 3 years. Some of those are in ethics, and some of them must be in elimination of bias, and some of them must be in substance abuse avoidance classes. Attorneys also network a lot by joining different community organizations. You'll typically almost always find attorneys that are members of the Lions Club or similar clubs. Sometimes attorneys will even join a referral group that might have a florist in it, a bunch of different occupations so that they can kind of cross-reference between each other. And you have to be careful about how that is done as well. Sometimes attorneys write articles to get their name out there, get more advertising, or they speak at conferences. Okay, so there's some exceptions to solicitation rules, soliciting business. And the big ones that apply to every attorney are the attorney referral services. So if you go to the courthouse, a lot of attorneys pay for LRIS, lawyer referral, and so if you need help, you'll get sent to an attorney who will charge. A lot of people also get, as part of their employment contracts, prepaid legal service insurance premiums, and they can get some free legal help through that. So those people can contact without worrying about solicitation as much. And when we're doing pro bono events, free events, we can also have a little bit more leeway in how we advertise that event because we're trying to help the public. All right, so when does the attorney-client relationship begin? And also the paralegal-client relationship. So, the client's wanting legal advice. The attorney knows about that type of law, and the lawyer has given some advice. So that's essentially when the attorney-client relationship begins. And almost any advice that's related to law can start this relationship. So I had a prior student one time that gave some advice as a paralegal on U.S. Postal Service and how long it takes for them to deliver stuff. That could technically be considered legal advice because it was about a legal case. When we think about representing a client as either a paralegal in our paralegal role or as an attorney, we need to know about the subject matter or learn about the subject matter sufficiently to do a good job for the client. We need to be committed to the client. We need to plan to represent them from beginning to end, or if we're not going to go all the way like through trial or appeal, we need to make that clear up front. We're also making a commitment to the client to have reasonable communication with them. So going, for instance, 9 months without talking with the client or emailing them or writing them a letter is not good. We also need to make sure that both the paralegal and the attorney don't have a conflict of interest. And so one of the biggest violations that's going on in law right now is the attorney makes sure that they don't have a conflict. For instance, if you're doing family law, you can't represent the wife if you're representing the husband. But the attorney forgets and the paralegal forgets that the paralegal might have worked on the husband's case and now the wife's case at 2 different law firms. So we have to make sure that that's not happening as well. Also, another really big violation that we've already talked about is the duty of confidentiality. And this means even if I find out something about my client that's negative and it's from the paper, I'm not supposed to be repeating it. I'm supposed to be very pro my client. And I really have to watch how, even with the client's permission, how I advertise the success I may have had in their case. Sometimes just advertising, even with the client's permission, that I have won a case for them. Like if I advertise, oh, I won a criminal law case for this client, it still looks bad if I post it on Facebook with a picture and their name. Oh, this person was found innocent. But here's the problem with that. Even if I have the client's permission, some people assume just because somebody's been accused of a crime that there was, some smoke. Where there's smoke, there's some fire. So I am seeing a lot of violation of that right now, and it's upsetting because that can really affect the client from getting a future job, even dates online. So we have to think about all the ways in which we affect our client. All right, going into more detail about what it means to be a competent paralegal and attorney. So if we have a client come to us about bankruptcy and we don't normally practice bankruptcy, that's fine. But we have to get good enough at bankruptcy to do a very good and excellent job for the client. We can take cases that are not in our subject areas, but we need to make sure we get up to date on that area of law. We also need to make sure that we know how to use e-filing systems. So most of you had to already upload something on Canvas. It's very similar to how it's done in a court. And we do have to learn how to use technology if that's needed for the job. So a couple of you did put on your first assignment that you didn't like technology. We still have to get up to date. We have to do a very thorough and detailed job. We have to investigate the facts, and we have to perform legal research and make sure even laws that we know, we have to make sure that there's still good laws on the day that we go to court, for instance. Okay, let's talk more about what it means for commitment. Okay, it means as soon as possible, basically. Get the work done as soon as possible. That's it in a nutshell. All right. By communication, we have to give the client enough information about their case for them to make a decision. It's not the paralegal and attorney's job to decide the client's case, what they want to do in it. So, for example, if I have a criminal defendant and I think it's likely that he might be found guilty, then I need to let him know if there's any plea deals on the table and tell him how likely I think it might be for him to be found guilty, and give him my opinion that maybe it would be better to take a plea bargain. But it is ultimately the client's decision whether to plead not guilty or guilty, and whether to take a plea bargain, for instance. All right, so there's lots of different kinds of conflict of interests, okay? It's not just the case of the divorce where you represent the husband and wife. It's potential conflicts. You really have to try to foresee the future and think if there's any way in the future that you could be representing two people that are opposed to each other. All right, so confidentiality is so important in law. We shouldn't be discussing cases on the internet at all, pretty much. We shouldn't be discussing them in a public area, even in the law firm. If we're in the reception area and, other clients can be there, or at the elevator, we shouldn't be discussing cases. We need to be discussing cases only with the people on that case, and we need to make sure that the surroundings are, in fact, private. We shouldn't take phone calls from one client while we're in front of another client. One client doesn't have the right to know about another client's case. Receptionists, even at the law firm, when they're letting somebody know that their attorney is ready, should just maybe use first names, not even last names. Because if you're a criminal law attorney, just saying somebody's full name in the reception area where other people are present is violation of attorney-client privilege. It is confidential that these people are going to, all these different clients are going to different lawyers. That is private information. Don't go and tell friends who the clients are. Don't describe clients in sufficient detail to figure out who they are. If there's a news event and you talk about a very similar traffic accident that happened that day, you cannot do it. It has to be so general. And if in doubt, do not talk about clients. Even when you leave your computer, you need to have a screensaver so that other people in the law firm who are not working on that case do not see information about that case. That's how intense it is and how much we really need to keep our client's business private. All right, so I do allow some of my clients to have my personal cell phone number, but typically I try not to take client cell phone calls because I want to make sure I'm not forgetting ever that I need to not say anything in a public arena on a cell phone that would violate attorney-client privilege. When I send something via fax, which we still do sometimes in law, I need to try to make sure that that is a fax machine that's only going to go to the client. Even when I do have a conversation on a cell phone with a client, I make sure that it's very general and I'm not talking about anything that I would ever want out in public. Computers. I have a laptop. If I take it out of my office, it's basically wiped clean and I have things on thumb drives and stick it in that computer. When I'm crossing the border, I need to have a clean laptop because it is allowed for USCIS to go ahead and stick something in my computer and get data off of it. So I need to have a clean laptop. I cannot leave a computer with any client data in my car because what if it gets stolen? I have to be so super careful and I have to have passwords on everything. And even with the passwords, I need to make sure the stuff does not get stolen. Now, the client can divulge information and consent to divulge information. But me as an attorney, I still should not be posting innocent clients' pictures on social media because that can negatively affect their ability to get a job, date, whatever. Okay? If I need to prevent a crime, I can violate attorney-client privilege. For example, if I know where a dead body is, I'm required by law to go ahead and tip off anonymously the police as to where that is. I may not always violate confidentiality when the client commits perjury. That would be in a criminal case. If the defendant wants to get up there and lie, I can't help him lie, but he's allowed to get up there and lie. Sometimes I might have a court order to violate attorney-client privilege, and I usually almost always wait till that happens just to make sure I don't get sued by my client for violating attorney-client privilege. Sometimes, to defend myself, I can violate as well, but typically I'm almost always going to wait for that court order. Okay, so one of the things that we also do is if we have written materials or electronic materials, we try to stamp them with attorney-client privilege if it is in fact attorney-client privilege, just to remind everybody that it shouldn't be disclosed. And this is only for communications between a lawyer and a client. By extension, you could argue with the paralegal too. The lawyer would need to know about it. It can't have a third party there. It can't like have the mom of the client there. That would violate attorney-client privilege. It wouldn't be privileged then. The communication must be made in order to get legal advice. So if you have a client saying to you, the paralegal, well, what about this DUI I've had in the past? You need to stop them and you need to tell them you need to tell the attorney. Okay, so we have attorney-client privilege. Okay. Now, confidentiality applies to public information that I learn about the client that is not favorable to them. But that's not attorney-client privilege. Attorney-client privilege is even more protection than confidentiality. And with attorney-client privilege, even after a client has died, I may not reveal things that they asked me to get legal advice for. Okay, so once the client has told me stuff and I need to work on their case, it's called attorney work product doctrine. And it's all my thoughts, my work, and getting their case set up. And this does apply to you much more than the attorney-client privilege does, which is pretty iffy when it comes to paralegals. And that's why I said, if the client starts to confide in you, tell them, stop, go talk to the attorney. So what are some things that can be attorney work product? Memos, telephone conversations, notes of meetings, legal research, emails, anything made in preparation for trial and not exchanged with the other side typically is going to be attorney work product. Now, when does the attorney-client relationship end? The client can end it at any time. The attorney can only end it in a civil case if they haven't been paid and it's not close to trial. And in a criminal case, even if the attorney has not been paid, they cannot necessarily end representation. Now, why do we care about all these rules? Because we can get suspended from practicing and disbarred from practicing. And so these are the 5 nationwide types of attorney discipline. I'd like you to really read the state of California discipline keys though. So disbarred, suspension, resignation with discipline charges pending. Okay, you go ahead and you resign because you think you're probably going to be found liable or guilty. Usually disbarment is not permanent. It's usually for 10 years. And then the attorney can apply to be reinstated. So please make sure that you read these 2 discipline keys. I like to test on them for the final. Okay. Other ways attorneys can be punished for violating all these rules is they might have to pay the client back. They might have to retake an exam on ethics. There's criminal charges that can be brought, and they can also be civilly sued. So the consequences are very high. We really get to help people, but we have to be so super careful to not violate both the paralegal and attorney's professional rules of responsibility, which are extremely high in the state of California. And if you have any questions, feel free to ask me. I want to see you guys succeed, and it can be a little bit tricky not violating these rules. If you have a specific case you want to talk about, make sure you don't reveal any names or identifying information. Okay? I think you're going to be fine. Just be cautious.